As Matthew McConaughey once said, all right, all right, all right. So here we are. We're talking today about some of the meat of the class and getting into analysis and rule-based reasoning, generating exam answers, and how to present those answers in a coherent way. Let's get into it. Okay, you've certainly read this acronym before. You've heard it before, probably without the erudite boxer there at the bottom, which makes this more special. But generally, exam answers, and thus your exam writing, will follow the format of issue, rule, analysis, and conclusion, which we call IRAC. As always, you should check with your professor to see if they prefer this format for their exam answers. Most do. Some will utilize something called IRAC, which is conclusion, rule, explanation, analysis, and conclusion. And LRW has their own preferences. It's a whole different kind of writing. We're dealing with exam answers here. But check with your professor. It's quite likely that they prefer IRAC, especially for first year classes. But it's always good to be sure. You want to give them the material in the way that they want to see it. That's really what we're talking about now. How you demonstrate what you know. And part of that builds upon last week, where we did some elementary rule-based reasoning considerations. That's really the heart of what IRAC exam writing is about. So rule-based reasoning is really applying the language of a rule to a set of facts to predict an outcome. As with common law, the principled holding of a case typically isn't limited, or as lawyers sometimes say, cabined, to the facts of that case. Of course, it has general applicability, and that rule can, at once abstracted from that case where it arose, can be used to predict an outcome for a wholly different set of facts. It's the nature of our legal system and exams, and it's used on all different kinds of exams. We'll talk about issue problem questions and problems in a couple weeks, I believe. It's a little more difficult to because the issues aren't thrown right in your face, but it's a lot more fun because you can be more creative in an issue spotting exam, in my experience. More commonly, you'll get IRAC kind of problems, as we'll talk about in just a moment. Examples. So the first step in drafting an IRAC is to identify the issue or issues involved. The interaction between the facts and the rules creates the issues. In other words, an issue statement is capturing that interface between the facts of your case and the black letter law, the rules. Whether or not one or more rule components is met may need to be addressed. Remember the goal of what you're doing here. You're trying to show your professor that you understand how the law works. It's not like engineering. Well, engineering you have to show your work, but it's not like in an exam where you have to get the correct numerical answer, and if you get the correct numerical answer, you did it right. Here, you could have the right answer, but if you don't explain it well or present it well, your professor won't always see where you're coming from and won't appreciate your understanding. So when you first encounter the problem, that's where you first start to demonstrate your competency in legal analysis. How? Well, you perceive within the facts of the problem what issues need to be resolved and accordingly which rules are going to be implied by the facts of the problem. After you set up the rule, you then proceed to conduct an analysis of that rule in light of the facts of the question. And that is the rule-based reasoning that we practiced last week. You'll do it over and over and over again. The exercises from last week were designed to make you comfortable in that space to see how everything started working together. So, as I've identified already the rule that will be applied to address the issue implicated by the facts of the question. You then have to go through each element of the rule to determine whether or not that element is present. To do so, you have to be able to recite that element with clarity. You have to identify the facts that are relevant to that element or component of the rule. You may commonly have to articulate your understanding of the fact, and then specify the result that you obtain through that analysis. Element A is present, element B is present, C and D are present, and therefore I can conclude that this rule is satisfied, that there is a battery, for example. This example could be battery. Was there an act? Was there intent? Was there an intent to cause harmful or offensive contact? And was there harmful or offensive contact? For example, those could be the 4 elements in analyzing a battery circumstance. Well, once you go through each of those 4 elements, you can reach a conclusion. If one of the elements is missing, well, you reach the conclusion that there wasn't a battery because. After you go through each of those elements in your answer. And that's the C at the end of the IRAC, but we'll get there in a moment. So writing the analysis / application, different people call it different things. It's the analytical part of your answer. The suggestion that we make to you and the formulation that we use to emphasize this deliberate nature of developing an exam answer, we call a full analysis, FUL. And that stands for the fact. So which fact in the question relates to this component or element of a rule? Your understanding of that fact, if it's necessary. Do you need to draw any inferences or state any understandings from the fact to link it to the rule? And let me give you an example of that. Let's say you are analyzing an assault question in tort. And the person who is the person who is the assaultee, one might say, the tortfeasor just throws a ball at another person, misses, but that person winces. Okay, sounds like an assault. But what do? You go through the steps. Was there an intent? What objective evidence supports the intent of the ball thrower? And an understanding of the fact, if necessary, is what I want to emphasize here in a very rudimentary, almost silly sense. The wincing that individual undertook when the ball was thrown at them needs to be explained. Wincing isn't an element of assault. If you look at any restatement, it doesn't say wincing. It's an anticipation of imminent harmful or offensive contact. Wincing is evidence of such anticipation, but draw the connection. Here it may not need to happen, but it's an example of where you can say, and it's easy enough to do, it's always worth doing. Sally, if that's the person at whom the ball was thrown, winced in anticipation of the ball striking her, satisfying the element of that anticipation element. So, sometimes the facts easily demonstrate these things, like the wincing example. Sometimes they need a little more unpacking for you to show the professor that you know what you're talking about. Always err on the side of more thorough explanation. there's a line at which that becomes pedantic. You'll learn where that is as you practice these kinds of questions. But if you always err towards more inclusion, it's easier to pull it back in editing your answer or in later practices, because you really need to practice being deliberate. It's very difficult. It was difficult for me to make that transition. I was used to making internal logical jumps when I drafted answers, and I needed to slow down, take a step back, and take individualized steps forward by articulating the details of my understanding. It took a little discipline on my part to undertake that kind of elemental, incremental breakdown. But once I was able to do it, I was able to do it efficiently. So finally, in a full analysis, you link the facts to the to the language of the rule. So your fact and understanding of that fact must link back to the rule, explaining why the facts make it more or less likely that the component will be met. Sometimes it's, you can make that probabilistic. A reasonable interpretation of the tortfeasor's behavior is blank reflecting an intent to cause harmful or offensive contact. Sometimes they'll say it, and you won't have to make that inference. I'm going to strike you with a ball on a railroad or something, because all tort cases are on railroads in the first semester. So, there's sort of a train somewhere in the question, probably. But you have to tie it back between the fact, you have to tie the facts to the rule with your understanding. And that linkage is really what demonstrates your understanding of the law, really. So here's a brief question that we're going to go over now. I'm not going to read it out loud, so I'll give you a second just to read it to yourself now. Okay. This is not me. Because I don't own a restaurant. I'm sorry if you can hear the screaming of my daughter in the background. That's just how it is. Okay. So, basic kind of contract question, right? One of a typical variety of contract questions where you assess whether there was a valid offer. Note that the call of the question, which is that last line, doesn't ask if there's a contract. It asks if there was an offer. So when you're writing an answer to a question, the first tip I'll give you is to make, obviously not the first, we're on whatever the 8th slide and 13 minutes in, but the next suggestion I will make to you is that you want to be very aware of what the call of the question is. Because if you start writing about how there is or is not a valid contract, well, that's fine, that's good, but it's not what the professor is asking here. You want to make sure that you hew closely to the call of the question, and here that is evaluating whether or not there's a valid offer. So in this sense, the question provides you essentially with the issue, and that's very helpful. This is a typical IRAC kind of question, I would call it, as opposed to an issue spotting question, where it may have these facts and just say discuss. In those kinds of questions, it's fair game to talk about the contract, whatever, the obligations of the parties, whatever, blah, 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 offer, acceptance, consideration, all those things. But if the question is calling out for you to discuss whether there's a valid offer, that's what you should discuss. And I say this in my patent application drafting class, it's not Shakespeare. You want to be clear, you want to be articulate, but you don't necessarily need to be pretty or perfect. You need to convey the points that are relevant to the professor to demonstrate your understanding. And that starts in a question with recognizing the call of the question, i.e. the issue that you need to address with your answer. Here, whether it's a valid offer. Again, the question gave it to us. Was Baker's letter to Jim an offer? Under, of course, the appropriate standards for contract law. Well, let's check it out. But before we do, there's a value in stating the issue and in thinking a little bit when you formulate the issue. Your recitation of the issue will implicate which rules to utilize in your answer. And that I can demonstrate straightforwardly to you. Because the issue for this question was whether there was an offer. Accordingly, the rules that you're going to utilize in developing your answer are going to be those relating to offer. If you had formulated the question, in spite of what it gave you, as to whether there is a valid contract between the parties, well, you'll have some of the same rules because you still need an offer. But you will be talking about a lot of things the question isn't asking, and therefore you're utilizing rules that aren't relevant to the call of the question. It can be helpful, but frankly, on these exams, you're really pressed for time in a lot of instances. So what you want to do is hew closely to what the question asks. I promise not to say hew again, but I think you get the idea. Stick with what the question asks. So in this instance, what rules... Sorry about that. My daughter is adamant that 3 p.m. is a great time to brush your teeth. And she is making that point with tremendous force to my mother, who's watching her right now. Anyway, so what rules are implicated in this question? Here's the basic statement definition of an offer from the Restatement Second of Contracts, Section 24. An offer is the manifestation of willingness to enter into a bargain, so made as to justify another person in understanding that his or her assent to that bargain is invited and will conclude it. Lucy v. Zamer stuff, right? Stuff you did very early in contracts. But this is a rule that's implicated, right? This is what an offer is. So you have to measure the facts against this rule and the elements of that rule. Are any other rules implicated? In class, I'd just wait a while until we could talk about it, of course. But given we're here, I'll just go on and say we also know from the basic contract law content, rules and content, that a valid offer requires an intent to be bound, definite terms, and a communication of those terms and intent to the offeree. All right, those are the basic rules that are implicated here when you're evaluating whether or not there was a valid offer. And my transitions, once again, are questionable. But now we're into the analysis. They lead to the exam answer structure. Based on the rules, what do I have to prove or establish to reach a conclusion? So once you write out the rules, you'll know that to have a valid offer, you need the intent of the offeror to be bound. The offeree believes that her assent is invited and that she can conclude the contracts. There are definite terms in the offer, and there is communication of terms and intent to the offeree. So here's a chart you can use when you first start working on these kinds of questions that I think is really beneficial. And here's why I say it's beneficial. And again, like many aspects of the class, it may seem pedantic. I recognize that. Nonetheless, these are things, frankly, I wish I knew in such detail when I was in school. My first semester was a bit of a mess, honestly, because I was used to very different educational structures from grad school and undergrad, and I needed to have it broken down for me and then reconstructed it. Once I went through the basic steps a couple times, I was like, oh, okay, this is what I was doing wrong. I was making these logical jumps. I was omitting information that would help support my analysis. I got to be more explicit. And I went through that after going over my midterm first year. And frankly, I went through the same experience when I went through my exams at the end of first semester. I may not learn quickly. It's just how I am. And it took a little while to sink in. Even though this chart may feel basic, middle schooly, high schooly to you, if you go through this process a handful of times, you'll start doing it in your head. You will automatically start undertaking your analysis this way and approaching your analysis this way. Once it becomes that sort of second nature to you, you won't have to make charts. Of course, you're not going to make a chart on an exam, but when you practice answering these kinds of questions, particularly at the beginning, these things are gold. Why? Because they force you to slow down. They force you to be explicit. And that is a skill as important as any in law. It is very difficult when you're in the heat of a moment in a piece of litigation or an oral argument to be analytical. Some people, like myself, my Irish blood boils, right? And I end up getting very emotional. I don't anymore because what do? I go back to first principles and I just undertake an analysis even standing on my feet in front of a adjudicator. So it's really a step along the path. If these annoy you, I'm sorry. I can understand why. But boy, they're useful. They're gold. Do it a couple times, you'll see what I mean. So let's get back to our question here. What's the rule component that we identified first? First, an intent to be bound. That is, would a reasonable person believe that the offeror intended to be bound? What's the fact that's relevant? Well, here, a week prior to the letter, Baker and Jim had extensive conversations about Baker coming to work at the cafe. That's pretty good evidence of an intent to be bound. Why? It would cause a reasonable person to believe that Baker intended to be bound by the offer because they had just gotten finished having extensive conversations. And those are the kinds of things you do when you expect to be bound by an agreement. Like if they just said it in passing, a la Lucy v. Zamer, then maybe it would turn out differently. But here, we have different facts. We have extensive conversations a week prior. That is good evidence, and it would likely cause a reasonable person to believe that Baker intended to be bound by the offer. So what's the result? A check mark. In other words, yes, that element is present in these facts. Are the terms definite? Well, the position's set, head pastry chef. The term is set, 2-year term, and the salary is set, $100,000 a year. Is that absolutely everything that needs to be worked out? Anybody who's been employed anywhere knows probably not, but that's plenty definite for what we're talking about here. The terms are specific, and they would allow Jim to conclude the contract by accepting. And of course, we resultingly get a check. The third element, was there a communication of intent and terms to offeree? Is the offer, in other words, communicated to the appropriate party and with the appropriate degree of clarity? Baker mailed a letter to Jim stating, I will work for Cafe as head pastry chef for 2 years and annual salary of $100,000. So that is an explicit statement of the intent to be bound. And as such, it doesn't have to have an understanding articulated. I'm sorry, I'm laughing because my daughter is screeching and I don't know why, but I'm glad I'm upstairs. Anyway, so in this instance, this fact doesn't need explanation. It stands on its own. Did Baker have an intent? And did he or she communicate those details to Jim? Well, yeah, that's exactly what he said. So there's no reason to explain it further, but that element is met. So how do you write about it? We know from the analysis of the last slide that, yeah, all the elements are met, so accordingly it is a contract offer. Great. How do we communicate that to the professor to demonstrate our thorough, complete, subtle, and deep-held understanding of the law? Well, you use a particularized structure. Again, this isn't Shakespeare. Here's a typical answer. I won't call it a model answer. Model answers are a little different. As you probably have noticed, model answers seem to be written by people who write restatements with an indeterminately long period of time to write the answer. Right? They answer everything they can think of. That's not what a typical answer should always look like. Commonly, it doesn't look like that. Instead, you use the model answer as they're presented as a sort of check on all the issues you could have brought up. But here, we have a typical answer that we're going to talk about. So here's the analysis that may be presented for intent. It's important to use signaling words. And I'll present these in a later discussion of IRAC in a very consolidated form, so you have them all together. But I'll note them as we proceed through this answer for your benefit. Starting with a word like first, perfectly fine. It just feels good to read that because, I know you know where we're starting. We're starting at the very good beginning, a very good place to start. And you just go on from there. It also identifies for the reader what you determine to be the first element to address. It must be determined whether Baker possessed the intent to be bound. If I'm the reader and professor, I say, okay, this person identified the right issue, the right element. Let's see what they have to say about it. Then you give a rule. Intent is assessed according to a reasonable person's standard. Specifically, if a reasonable person would have believed the offeror intended to be bound, then the offeror possessed the requisite intent. What is that? A rule statement. There's a general statement and then a specific statement tying a recitation of the rule to, reciting a particular phrasing of the rule that's particularly relevant and appropriate for this question you're addressing. Then so far what's happened? You've presented an issue, you've presented the rule. Now you go to analysis, which is in vibrant red against the blue background, and you start that analysis commonly with here, comma. And what are you saying? Okay, those are the general things that are true, and here, for our facts in this question, I'm going to tell you about some facts in our question. Okay? So it really communicates to the reader that you are progressing to the analysis portion of this IRAC, sub-IRAC, whatever it is. This part of your answer addressing intent has to have that. It doesn't have to have the here, but boy, it helps. Because I then know that you're going into analysis, and I switch the way I start reading your answer. So what is in an analysis? What is in an analysis? The stuff we just talked about with the full chart. You have your facts, understanding, and linking the facts and understanding to the rule. So what do you say? You start talking about facts and then start applying those facts to the rule. Here, a week prior to sending the letter, Baker and Jim had extensive conversations about Baker coming to work for the cafe. In light of those conversations, a reasonable person would believe that Baker intended to be bound by the terms recited in this letter. So you see in the first sentence, it's just the fact. In the second sentence of the analysis, you tie that fact to the element of the rule that you're discussing. After you do so, you should have presented sufficient information to have convinced yourself and the reader that that element is satisfied. So you reach a conclusion and say, therefore, and that's a very common start to the conclusion section. Accordingly is another one that I use a lot. Therefore, Baker possessed the requisite intent to be bound. Boom. You tidied up intent. Intent's done. Yep. Okay. Go on to the next component of the analysis of there was an offer. Next, to be an offer, and that next, to be an offer, tells the reader that you're going on to the next element, and you call back, sort of like a stand-up comedian, right? You call back to the issue. To be an offer, that reminds the reader that you're still talking about whether there's an offer. So Baker's email must justify another person in understanding that his or her assent to that bargain is invited and will conclude the contract. Here, there's that transition word. We're into the analysis. Jim, as owner of the cafe, would have understood that he was capable of concluding the contract, with an R typo, by accepting the terms recited in Baker's letter. And then, why do I think that? Not only had Jim and Baker undertaken serious discussions regarding the possibility of employment, Jim would recognize that the terms recited by Baker reflected reasonable terms of proposed employment. As owner of the cafe, Jim would know that by assenting to the terms, a contract would be concluded. So you provide facts and link them to the standards of the rule, the elements of the rule, to say, therefore, this requirement for Baker's letter to be an offer is satisfied. Next, see, it's not Shakespeare, it reads kind of boring. You know what this kind of answer does? Demonstrates that you understand what's going on. And again, that is the purpose of this legal document. Every legal document has one or more audiences. And as you progress in your legal career, you should always think before putting pen to paper, for whom am I writing this document, this instrument, if it's a contract, if it's a patent application, whatever it might be, you have to think about who that audience is and what you're trying to accomplish. Here, what you're writing is an exam answer for the professor to be firmly convinced that you know what the hell you're doing. So you put stuff in that helps the professor or reader determine that. Things like next, here, therefore. Again, not Shakespeare. So then you say, next it must be determined whether the letter reflected sufficient detail to qualify as an offer to enter into a contract. So that's again an issue statement, sort of a sub-issue. The broad issue is whether or not there's an offer. And below that are these three separate issues that we've now talked about. Again, you go through the details. You state the law, the rule in the first paragraph. In this instance, you say here, Baker's letter, go through the facts, reach your legal interpretation of those facts, that they are specific and definite. Therefore, this requirement for Baker's letter to be an offer is satisfied. You can say that differently. Therefore, there's sufficient detail in Baker's letter for it to qualify as an offer. Go into the final element. Finally, again, is one of those things that lets your reader know you're coming towards the end. For the letter to be an offer, it must be determined whether, go through and read it. Here, comma, you talk about the facts and how you link them through your understanding to the rule. Jim received the letter and was aware of the content. It was communicated to him. Therefore, this requirement for Baker's letter to be an offer is satisfied. So, then, again, you addressed, by this point, each element of each subpart of the rule to determine whether or not there was an offer. So, in your conclusion, do you just say, because of the above, there was an offer? No. That isn't the best way of communicating that you know what you're talking about. That's a conclusory statement. It's a conclusory statement, but A better way of saying it is not to be conclusory, but rather to elaborate. You say, because A, Baker possessed the intent to be bound. B, Jim would have understood that his assent would be sufficient. C, Baker's letter contained definite terms. And D, Baker communicated the intent in terms to Jim. Therefore, or because of those things, Baker's letter to Jim was an offer. End of transmission. Because by communicating this as your conclusion, you remind the reader, yep, I identified these issues to be resolved. I resolved these issues in the following way. Accordingly, the conclusion I reach is it was an offer. You then will later include the next part of an answer, which we'll talk about in another class, which are counter-arguments. So some facts, of course, are open to more than one interpretation. That's generally true. But particularly on law school exams. So you may ask yourself, when should I bring those up? I just like the soon meme. This looks like a pretty disturbing situation for this diver, but I just think it's funny anyway. But we will bring them up soon, in the next couple of weeks. So, assignment for next week. It's problem 310. I'll post it. It's more, like I said before and earlier, when you put the source for your material somewhere in your outline so you can find it later. Problem 310 reminds me of where I got it. So in this question that you'll be addressing for your assignment next week is applying the mirror image rule. It's just a different set of circumstances. And to make it easier for you to learn how to do the writing, here are the rules you can apply. So really what we're doing with this assignment, think about it, is learning how to craft these answers. You'll do other practice where you don't get the rules fed to you. Of course, on the exams, you won't get the rules fed to you. But, at this point in our interaction, you should be starting to know the rules by heart, just by constant interaction with them at the least, but also if you've been doing any flashcard work or forced recall or other kinds with a blank sheet of paper and just writing what you remember, going and studying what you don't, and then doing it again in a couple of days to see what you've learned anew. Even though you should be learning these rules, my concern with this assignment is not whether you know the rules. Look, you can get them, you'll get them the rest of the semester, that's fine. What I want you to practice this week is applying those rules and creating an answer that can be, that will be an effective communication of how much you know, and will hopefully put you in a good position when your professor is reading your answer.